I've got an amazing two-parter for you. My name's Ian Garlic, and we're going to talk about two of the biggest verdicts, personal injury verdicts in New York State. And one's a $10 million case and one's a $117 million case. Both of them went to trial. Both of them are super interesting. I'm going to talk with Steve Williamson. We're going to talk about what it takes to get one of those large verdicts. What the big mistake that most attorneys make when they're entering the courtroom during those types of verdicts. In the first one, we're going to talk about Sarah Lawrence College and a slip and fall case that ended up in a $10 million verdict. We're going to talk about what the impact to the person injured, Miss Bako, what that meant to that type of verdict, what type of impact she had on her life, why the elderly are sometimes taken advantage of in court, and the big mistake with juries. And then in the second part, we're going to talk about a $117 million verdict. What it takes to get something that big without there being a massive death or anything like that. This first one is amazing. Make sure to stick around for the second one as well. And don't forget, True Law Stories is brought to you by videocasestory.com. One of the biggest ways to win trials and one of the best ways to win business for your law firm or any business is through Video Case Stories. We'll help you strategize those stories, collect those stories, and craft amazing stories. Just go to videocasestory.com/get started to get your initial free strategy session. All right, let's get started.
Steve, before we get started talking about these cases, tell us a little bit about your background as an attorney.
So I'm a plaintiff's personal injury lawyer in New York City, and I've been doing this kind of work for over 20 years. It's all I do. And what that means simply is I always am representing individuals and families, regular people who get hurt in some kind of incident, whether it's at work or otherwise in a car, and they suffer injuries and they can't work or they can't work like they used to. And the injury and the incident is a big impact on them and their families. And I'm always on the side of the injury victim, never representing big corporations on the other side or insurance companies. And my clients are regular, hardworking New Yorkers and people from all over the tri-state area, generally middle-class folks who work hard and play by the rules.
And in 20 years, we're talking about big case, but how often have you seen where, and I mean, I know you're a plaintiff's personal injury attorney, but how often have you seen where it goes so egregiously against the defendant that the jury just got it all wrong?
Where the jury gets it wrong?
Yeah, where the jury gets it wrong against the defendant. Where, let's say we're going to talk about these big cases where you feel the jury got it right, but how, when you think back in it, how often is the jury just gone against the defendant and said, oh, you owe a ton of money, and just really made no sense whatsoever?
I can't say that I've ever seen that happen. There are some lawyers who do complain about the jury system and about juries and how they come out with outlandish results, but that has not been my experience. In my 20 plus years trying cases, I've found that jurors generally get it right. They generally see the truth of a case. They see through the distractions and the smoke screens that can be put up by lawyers, and they generally get to the essence of a case and come up with the right answer. And even when I've had losses in my career, I've always understood why the jury reached the result that they did. It's never been inexplicable for me. And when I win a case, it's a case that I should win. I don't think I can think of one time where I won a case that I should have lost. And as I said, when I've lost cases, I think it's been a mix, but I've understood how and why the jury ended up where they did. So my experience has been that jurors get it right. And I have never seen an instance where a jury comes up with a result that's very far off the mark. And so, for example, two dissimilar examples, I've never seen a righteous case where the person really got hurt and it was really the defendant's fault and the jury says no to that. I've never seen it because jurors want to do the right thing and they generally do the right thing. And similarly, I've never had a circumstance where there's been a big result, a big plaintiff's verdict, and it wasn't warranted. They get it right.
And I want to talk about this $117 million pedestrian case, but first I'd like to talk about a little bit about the trip and fall case, the Bako case, because I think that it's a great story. There's an amazing longer case story about it out there, but little behind the scenes when you think of a $10 million trip and fall case. And can we a little bit about the details about what the injury is, and how do you end up at $10 million for a trip and fall case?
I think the jury reached the result that they did for a couple of reasons. One, I think they felt that Miss Baco's life was really changed in a very dramatic way from the injuries. I think that they saw the long road that she had traveled from the time when she first got hurt up until the time of trial. And I think that they appreciated that she was so honest and forthright about her past medical problems, because that was a big issue in the case. The defense was trying to say that whatever problems we were pinning on the incident were pre-existing, that she had them before, and that just wasn't true. And I think they, in part, gave the result that they did because they understood that this was a woman, because of her age and the medical problems she had when she got hurt, that she was in a fragile state. You know, we have a concept in the law called the eggshell plaintiff, and it basically means you take your plaintiff as you find him or her. And if you are negligent and you cause someone to be hurt, if that person is hurt worse than a young, normal, healthy person, either because they got some pre-existing infirmity or disease or age, and they're more fragile, they're more susceptible to having a bad result, that's the responsibility of the wrongdoer, as it should be, because it's a reality, it's a fact of life. And there's only two folks who could bear that burden. It's either the injured plaintiff or the wrongdoer. And the law takes the view that between those two, it's the wrongdoer who should shoulder that additional burden. And this is a woman who was doing okay. She was living life in a way that was independent and functional and normal to her. But she was older and she had a lot of health problems, and she could ill afford to have something bad happen. And when she got hurt in this incident, it was like the tipping point. You know, the way I described it at one point in the trial was her cup was already full, but she was managing. And then this was the thing that knocked the cup over. And I think the jurors really understood that. And they didn't like the fact that the defense refused to acknowledge those realities. It refused to acknowledge that she was vulnerable and this made her worse, but instead tried to use all her past and pre-existing problems as a way to blame her and to say that whatever she's claiming, it's not from this, it's from before. So those are some of the elements that went into the jury reaching the result that they did.
And when you're approaching a jury with a case like this, and you're telling that story, and you, like you said, she was completely open and honest. How do you approach it with that open and that honesty, and make sure the jury feels it while still presenting a case?
Our approach and our perspective is that we respect juries and we respect the jury system. And we think that jurors, once they get selected and once they get over the initial reaction of, oh, I'm going to be away from my family and my job for a few weeks and I have to do this public service. But once they get past that initial hesitation, they throw themselves into it. And they want to do the right thing. Jurors, like community members at large, are good people. And so we have a certain faith and trust that we put in the jurors. And we try not to play games with them or lawyer them. We lay out all the facts and all the issues in the case, the good, the bad, and the ugly, because that's what life is. That's what reality is. There's no perfect set of facts. There's no pristine scenario. There's always a mix of things that you have to put forward. And if you just put forward the positive and you try and hide the negative or ignore the issues that may be not great for you, jurors see that and they see it for what it is. And then either the other side has the opportunity to grab the weaknesses and mischaracterize them, or the jury sees you as something less than being completely forthright. But if you take all of it and the good and the bad together and you put it to the jury, and with a sense of faith and trust that they're going to be able to sort out what's meaningful and what's logical, they generally not only get to the right result, but they appreciate the approach, because I think jurors are looking for who they can trust in the courtroom. When they serve in a trial, they're in a new and foreign environment to them. It's familiar to us as lawyers and to the judge, but being in the courtroom and being in the trial process is new and unfamiliar to them. The only thing that they really bring are the stereotypes that they see from TV and otherwise. And so they're trying to figure out what's what and who they can trust in the courtroom and where the signals, credibility. And that's very important for us to seize on. And you don't seize on it by manipulation or gamesmanship. You seize on it by being straight with them and bringing that respect you have for the system into the actual courtroom and into the individual case. And I think they appreciate that and they get that.
What do you feel was the tipping point in this $10 million verdict? What point do you really feel like that they really got it and that you were telling the truth and that this person, that Ms. Bako really deserved this type of compensation?
I think it was the contrast between our approach and the approach of the defense. Right from the very beginning in jury selection, I told the jury, look, you may decide that this is a shared responsibility case, that even though the college was negligent and this was partially their fault, Ms. Bako may bear some responsibility for the fall, for the incident herself. You guys are going to decide. But she's never denied that she may have a role to play here and that she's going to, at this trial, accept whatever determination you make. And so we put it to them in that way, in that framework, saying, you're going to decide who's at fault. Similarly with the injuries, and I said this before, right from the beginning, we said this was a woman who was older and had a significant medical history. She had a boatload of problems before. She was okay, but not great, and this just was the tipping point that made everything so much worse for her and took her past a point of no return. And so that was our sort of strategy and approach from the beginning, and it was in marked contrast to what the defense did. They refused to accept any responsibility. They said that the incident was entirely Ms. Bako's fault, that they did nothing wrong, even though the evidence didn't support that. There was an eyewitness whose account very much put blame on the college. So on the incident, from the beginning, at the trial, they said this is all on her. And then they refused similarly to acknowledge the impact of the injuries. They said whatever she's claiming in terms of how her life has been changed, her suffering, and her need for medical care and medical costs in the future, that's all stuff that was there before. It's all from age, it's all pre-existing. And so I think there was a real contrast between their approach and our approach, and I think it spoke to how we looked at the jury and how we respected their intelligence and their common sense and their good judgment. Because if you've got a case where it really is the plaintiff's fault and the injuries are being exaggerated and you're trying to pin on the incident something that pre-existed before, then it's not righteous to say that. It's not going to stand up. And the defense is on solid ground in telling that to the jury. But either way, whichever way it cuts, you got to have the goods. And they didn't have the goods here. They were making arguments to the jury that they didn't have evidence for. And I think if you think about that, what it really is a disrespect for the jurors' ability to see through the gamesmanship and the lawyering and be able to figure it out. If you hold them in high regard and you think they're smart and you think they're going to see through the smoke screens and figure out what the evidence really is, then how could you go forward and say something that's unsupported? How could you say something that's not true? It's not going to do well for you. It's going to boomerang and backfire. And that's what happened here. And I think the turning point was a gradual thing. There was one moment in the trial, or there were several witnesses in the trial who were present the day of the fall. And what we brought out was that right from the first day, when they wrote up the incident report, in a way that completely blamed Yolanda for the fall. Blamed her completely, said that art installation was out of the walking path, that she wasn't paying attention. It was written very deliberately to completely blame her. But when we got the security guard on the stand and the independent witness on the stand, there was no basis for what was in the incident report. They basically spun it from whole cloth in a way to protect the college and blame her. And I think that if was a significant turning point, because the jurors saw that not only were they trying to blame her in the courtroom all these years later, but the blaming and the evading of responsibility began literally right at the outset, right after the fall.
And so how does that, like when they start to discover that, how does that translate into a $10 million verdict for this type of case?
I think it's just one of many factors that goes into it. I think at the end of the day, it's the human suffering. I think that when jurors sit through a righteous case and they hear from a real person who's truly been injured in a way that has been life-altering for them, and the evidence is real and it's compelling, I think jurors understand what we as plaintiffs' lawyers are always saying, which is that human damage to someone's life is priceless. It's really significant. We all live our lives in different ways, and we all have different priorities and things that we put emphasis on, but there's commonalities. We all love our family. We all love our kids. We cherish our time with our loved ones. And if those kinds of things are altered or taken away, the impact is tremendous and the cost is priceless. We will sometimes talk about people's economic assets and their non-economic assets. Our economic assets are precious to us. Our car, it's important to us. Our home is important to us. If we have luxury items like a boat, I'm sure those are precious to people as well. But they pale in comparison to our non-economic assets. Our kids are our non-economic assets. Our spouse, our other family members, those are the non-economic assets. What we love to do in our free time, how we enjoy life, being able to sleep through the night pain-free and wake up rested and happy and optimistic to face the day. Those are non-economic assets. And I don't care how nice your house is or how beautiful your car is, the economic assets are minuscule compared to the non-economic assets. And it's the job of a plaintiff's attorney at trial to make that known and to tell that story. And again, if you've got a righteous case where the losses are real and you've got someone, whose story is compelling, jurors can be very motivated to give them full justice. And so I don't think that $10 million verdict was too high. I don't think it was exorbitant. I think it was exactly the right amount for Miss Baco's suffering and everything that she went through in terms of the jury's perspective, in terms of what went down in the courtroom. There are other considerations behind the scene, legal considerations and other elements that the jury's not privy to, which ultimately go into the total end result of a case and how you arrive at that end result and what's fair and what's possible. But in terms of the presentation in the courtroom and what the jury sees and is reacting to, I think it was a very fair result.
And why, we were talking about it before, like that this is important too. Why do you feel like these types of results are important to people, besides just Miss Baco getting the money and making up somewhat for her suffering and able to help for the rest of her life? Why do you feel these types of messages from the jury are important?
They're tremendously important because they make our society safer. They keep us all safe. People, I think, lose sight of that, or they may not be completely aware of it. But the jury system, the tort system, is what keeps us safe on the roadways, from airbag safety and seatbelt safety to distracted driving safety. There's only so much that the police and the criminal side of the law can do. Regulations from regulatory agencies, they have their limits too, whether it's on the roadway or with consumer products and consumer safety and making products safe so that consumers, especially kids, don't get hurt, whether it's in the medical field with doctors and hospitals or with pharmaceuticals, medications, drugs. It is the tort system, and the threat of lawsuits and the threat that exists of cases going to trial and members of the community listening to these cases and deciding what the truth is and providing justice with money verdicts that holds wrongdoers accountable, that is, to a large degree, what keeps us safe. Because the criminal realm has its limits. You can only prosecute someone if they're guilty of a crime. All of these things that we're talking about with consumer safety, patient safety, roadway safety, and the like, all of that is beyond the reach of the criminal system. We have horrible crashes that occur on highways where people are killed and terribly injured, where someone was driving at a high rate of speed and texting at the time. And to the layperson, it's like, that person should go to jail. That's criminal. But oftentimes, and the laws have changed recently with texting, but for many years, there was no criminal remedy there. And that's an extreme example, but there are so many aspects of our society where the only guardian, the only sort of force from the government that's keeping us safe and putting forth and adhering to creating these standards and making people adhere to them is the civil justice system and juries. And so there's a huge public safety benefit to having cases like this be heard, having people having the right to bring these cases. And when a jury renders a verdict, like we saw in this case and in other cases, it sends a strong message to corporate America that they have to behave, that they have to adhere to reasonable safety standards, that they can't cut corners because of cost savings and the like. And we have to keep people safe in a way that's reasonable. And if we don't, there's going to be consequences. And I think the last point is it sends a message that if you hurt someone and you ruin their life, and then you refuse to acknowledge responsibility, you refuse to take accountability, and you drag someone through years of a litigation or a month-long trial without a just basis to do so, you may end up with a verdict that is not good. And in retrospect, it would have made a lot more sense to come to that family early on and say, you know what, we did wrong here, you got hurt, let's resolve this in a way that's fair so that you don't have to wait for justice and you can move on with your life and get closure. That's one of the hardest things for our clients, which is they have to wait so long to get justice. And during that whole process, they don't know whether it's going to end well for them. And they just don't get closure until years later. And that adds insult to injury. It really takes an additional negative element and hoists it on top of the original wrong, the injury, and the disabling effect of all of that. It's stressful for people to go through years of a litigation. It's incredibly stressful for someone to go through trial and to have to do that and essentially feel like you're being put on trial as the victim and feel that you're subjected to blame the victim dynamic really is incredibly hard for someone when they know that not only are they the victim, but they've been through years of suffering prior to that point. It's not easy.